Mr. Anderson, good morning. Okay, I see Ms. Beverly. So I think we have everybody now. Let's call our case. This is file number 20158-046, Open MRI of Livonia versus Esurance Property. This is a motion to enter default judgment on behalf of plaintiff Open MRI of Livonia, your respective appearances.
Good morning, Your Honor. Harolyn Beverly on behalf of the plaintiff, P44028.
Good morning, Your Honor. Zachary Anderson, P71605 on behalf of Esurance.
Ms. Beverly.
Good morning, Your Honor. I would rely upon my brief as well as my reply to defendant's brief in requesting that a default judgment be entered in this case. Your Honor, I feel, just so that I can make a record, we filed this complaint on July 6th of 2020. The court issued its first scheduling order on October 23rd of 20. Since then, Your Honor, I have sent 3 demands. September 22nd of 20, April 27th of 21, and May 3rd of 21. We have come to this court to get answers to interrogatories, which I still don't have, despite the stipulated order that was entered. I do not have written responses to our interrogatories or production requests. And most recently, on this 4-scan 0-pay case, an offer of 17% is very offensive, Your Honor, in addition to the fact that I have appeared here in court on a few occasions on this matter. So I am not understanding how there is a complete disregard for plaintiff's case, for me as plaintiff's counsel, for this court, for the procedures. I don't understand not appearing on dates that are duly noticed. I don't understand not appearing for motions that you file. Everybody knows that if you file a motion and you don't get a hearing date, you call the judge's chambers, you ask the clerk, hey, has a date been scheduled? I don't have it. Or you check the register of action, or you look at the civil Zoom docket, which 36th District is innovative in having, because other courts don't have a civil Zoom docket that you can check every single day. It seems to me that for many, many months, at least 7, this case has been pending with absolutely no action. And Your Honor, I fully believe that there's not been a sufficient showing in their response to my motion for a default judgment as required by the court rule and the case law. But if this court is inclined to entertain it, I would ask for cost, because the court rule requires that if a default is set aside, then there are costs that should be entered. And I would ask for $500, because this isn't once, this is twice, plus the lack of respect for the discovery process. I would also ask that I be allowed to depose the adjuster in this case, because frankly, Your Honor, this case has been in a default status for at least 6 months, because we've been waiting for things to happen, and this just doesn't make any sense.
Mr. Anderson.
Your Honor, I will start by addressing the discovery issue. Counsel has represented that I have not sent the discovery. Attached to my responsive motion are emails. I sent the entire claims file over on December 4th. On January 14th, I got an email stating that they could not open the link. We responded to them saying that the share file link, which is the program we use to send the claims file materials, that it will expire within 14 days if not open, that it will also expire if you forward it to another person. We then resent the claims file on January 15th. So we have responded to discovery. The allegation that I have not produced anything is simply not true. If they have a problem opening it, I can walk them through tech support issues, but nobody's called me and said the link doesn't work. I've been told it expired, I resent it, and that ends my obligation, short of them saying I can't actually open this link. So default for the discovery sanction would be extremely severe, and disproportionate based upon the case law I cited in my brief, because I have provided the discovery responses. In regards to the missing court dates that I missed, I admit I missed those 2 dates. Mail in Farmington Hills has been terrible over the past year. There are times where we get 3 months worth of mail in one day. I did not have notice of the last 2 hearings. When counsel emailed me regarding the original default, I emailed her back and I indicated that I was unaware of the court date. I asked if we could stipulate to set the default aside because I was unaware of the court date. She did not say yes or no to my request, which led me to filing a motion to set aside the default.
And then not appear for your own motion.
That is true. My secretary called 3 times. She does not recall the date she called. She did not get through to anybody. But then eventually I became aware of the fact that I missed my own motion. I admit that I did that. I wish I hadn't missed the motion. I was unaware of the motion hearing date. Counsel brings up the register of actions, checking the website, and all of those are, I don't dispute that those things exist. However,
Then why weren't they checked?
I didn't know prior that about the electronic register of actions. I was used to the computers being in the building and checking that way. I did not think to check the court's website. We had just been making phone calls. And unfortunately, we never got through to anybody when we would call.
Is there anything else you want to say?
Your Honor, default would be a harsh judgment in this scenario.
Default's already been entered. The question is whether or not I'm going to enter a default judgment. And the fact of the matter is, counsel, according to what you just told me, there are 2 court dates that you missed, including the hearing on your motion to set aside the default, which had been necessitated by what? Oh, your failure to appear for pretrial.
That is correct, Your Honor. I did not receive either of those dates in the mail for whatever reason. I can say this and I'll say it again. Mail has been terrible in our office. I did not receive either one of those dates.
When did you first realize?
Counsel emailed it.
When did you first realize you were having trouble with your mail?
We have been having problems with the mail for the past year.
Okay, so sometime in May of 2020, long before the court sent out either the notices that issue, you knew you had a problem with your mail.
Yes.
That's fair to say?
Yes, it is.
Now, what was done, sir, recognizing that you had this change in the reliability of your mail to keep you current with court dates? Don't you have a diary system in your office where files come up for review on a periodic basis?
We do review the files.
Indeed. And so you filed a motion to set aside a default judgment that was entered because of your failure to appear for a pretrial. How did you miss that when it came up on your diary date?
Well, I was calling. Well, not me specifically, but my secretary was calling. We just never got through to anybody. So we did make attempts to determine what date we should appear.
Let me make sure I understand what you're telling me in response to your claim about not being defaulted for failing to comply with the agreed upon orders for discovery. It is your position that you emailed the matters at issue. And then, having learned that there's a problem, you emailed them again. Is that your position?
Yes.
So apparently you have some familiarity with the internet.
Yes, I do.
Can you explain to me then why, since you have familiarity with the internet, the 36th District Court has had a website for longer, much longer than a year, you didn't use the website? Since you are familiar with the internet, you're a technological dinosaur like me, that might be one thing. But it seems to me what's happening here, Mr. Anderson, is that when you choose to be tech savvy, you are, then you decide, oh, I didn't know what to do with tech. Seems to be sort of inconsistent, sir.
Well, Your Honor, I admit I can see the inconsistency, and I'm just going to be honest and fall on the sword and say I did not think to check the website.
What prejudice would inure to your client if I do not set aside the default judgment based upon your failing to appear at the pretrial and your failing to appear at your own motion to set aside the default judgment that resulted from that.
My client would be prejudiced because the case would not be decided on the merits, as I cited case law in my brief that the Supreme Court and the Court of Appeals does favor decisions to be made on the merits of the case.
They certainly do.
It's a website.
They do not favor the ignoring of 2 court orders.
That is
You
true.
ignored the court order for the pretrial date. You ignored the court order calendaring your own motion to set aside the default that resulted from your failure to appear.
So, Your Honor, I did not ignore them. I did not have notice of them. While I understand the website exists, based upon my review of the court rules, and the court rules do not acknowledge the website and publication on the website as notice under the court rules.
Notice under the court rules, sir, is mailing by first-class mail to the address you provided with the court. Now, we sent notice by first-class mail, postage prepaid to your office for both the pretrial that you missed and for the motion to set aside the default judgment that you filed but failed to appear for the hearing. So under the court rules, sir, you had service. Please continue with your argument.
I do not dispute that it was mailed. I'm only saying that I never received the notices, and to this date, I have still not received either notice, and it is through no fault of the court. As we all know, the Postal Service has been having significant problems over the last year.
All right, anything else you want to tell me?
No, Your Honor.
Anything else, Ms. Beverly, you want to say?
I just want to clarify, Your Honor, to make sure that I'm clear here. The stipulated order required them to give us written responses to our answers to interrogatories and our request to produce. What counsel or defense did was just send over a claim file. There's not a single written response to an interrogatory or a request for a production of document.
Let's
Just
stop right there. Did you send written responses to any interrogatories, sir, as was specified in your stipulated order for discovery? Or did you only send the claim file?
The written responses are indeed late, Your Honor. They were sent yesterday, and they still need to be signed. So I do admit that they are late.
So let me make sure I understand. As we sit here today, you have failed to comply with the stipulated order concerning discovery by not sending in signed copies of the written answers to interrogatories. You failed to appear for pretrial. You failed to appear for the motion to set aside the default necessitated by your failure to appear at pretrial. Is that about where we are?
You are correct, Your Honor.
And is my math wrong? And is that 3 strikes?
That is 3, Your Honor. You are correct.
And the case law that you cited, in how many factual instances did you have a party fail to comply with the court order for the drastic sanction of default judgment was entered?
In the case law I cited, they do not specifically list in the portion that I cited how many strikes.
But you read the case. Tell me how many times you had strikes, if you would, in those cases that you rely on, saying that default judgment is too severe a sanction for failure to comply with the court order. Show me a case where it says 3 failures is too severe a sanction.
I cannot come up with a case like that off of the top of my head.
Anybody else want to tell me anything?
Your Honor, I believe that a default judgment is merited under the particular facts of this case. And again, if the court is not willing to do that, I would ask for severe sanctions because I have not had a case with 3 strikes like this, ever, in 30 years of practice.
This is my 43rd year. I haven't seen this before. Mr. Anderson?
Your Honor, I will simply say that my missing of the 2 dates was not intentional. There was malicious intent. It was simply due to factors outside of my control. Certainly, if I had made no attempts to ascertain the court date, that would be far worse. But my office did at the very least attempt to call to ascertain the date on multiple occasions.
Did I miss the affidavit of your secretary in that regard?
There is no affidavit in there. However, I can represent as an officer of the court that she made attempts to contact the court.
And what about your failure to comply with the terms of the order for discovery to which you stipulated? What's that?
That was an oversight on my part. We claims file over. I did not realize that my paralegal did not send over the interrogatory responses with them. I did follow up with her about that and made sure she got them over once I realized she did not send over the written responses.
All right, I'm done. I'm prepared to rule. Mr. Anderson, this is the sloppiest lawyering I have seen in a case that I have handled in more than 40 years. There's simply no excuse for your disregard to this case. You stipulate to the entry of an order for discovery, which you failed to comply with. Having failed to appear for pretrial, let's say that's excusable. You failed to be interested enough in the case to find out the hearing date for the motion on your request to set aside the default that came from your failure to appear. None of the cases that you cite involve a situation where you have 3 violations of a court order by one party, when the Court of Appeals said default judgment was too severe a sanction. This is the worst lawyering I've seen. But I do think that it would be inappropriate because there has been an answer filed. You have made some efforts, although incomplete, to comply with the order for discovery, to enter the severe sanction of default judgment. What I'm going to do, the court is going to deny the motion to enter default judgment and set aside the default, contingent upon payment of attorney fees of $750 by the defendant to the plaintiff within 10 days of today. And let me make this perfectly clear, Mr. Anderson, going forward. Any failure to comply with any order of the court going forward here will result in a default judgment, and I will not hear any more excuses here. You are responsible for the responses filed under the discovery rule. If they are inadequate, as apparently you agree they are, since you are now, months later, attempting to comply with the requirement in regard to interrogatories, it's your signature, not your paralegal's. It's your signature on the plea. It's your P number that is at risk. No more. All right, let me give you a date. We'll have you back, and I'll enter the order. Does June 17th work for both of you?
It does. Your Honor, if I may, the interrogatory responses, he says he's sending them, they're not signed. Could we get a date, maybe if by June 17th, because that's what I had written down, to depose the adjuster in this case?
Let's see how far we're going to go on this. Perhaps after a review of this file with his adjuster and doing the things required by the stipulated order for discovery, you might be in a position to talk about resolution of the file. So if we have not resolved the file on June 17th, Mr. Anderson, I expect you to come to that pretrial hearing if you join us this time.
I will be there on the 17th, Your Honor.
With the dates for the deposition of your adjuster. Is there anything else we can accomplish today?
The time on the
It'll be
7th.
10 o'clock like today.
Okay.
Mr. Anderson, Did you understand the court's order?
Yes, Your Honor. I am going to make one request, and I will understand if the court denies it. The checks are not generated within my office. I have to request the check and it has to be mailed to me. Could I ask for could I have an additional 4 days to get them the attorney's fees check?
You can have 17 days. And
Thank you, Your Honor.
Let me make it very clear. Setting aside the default is contingent upon timely payment, and that's $750. Do we have anything else that I was unclear about?
I am clear, Your Honor.
June 17th, 10 o'clock. Thank you both for coming in. You're off the record. You'll get two.
Judge, you'll write the order out, or do you want me to submit some?
I'll write it out. You're going to get two separate orders. You're going to
Thank
get an
you.
order calendaring the pretrial. You get an order denying the motion for default judgment for setting aside the default. That setting aside the default will be contingent upon payment of $750 in attorney fees within 17 days of today.
Thank you.
All right.
Thank you.
Have a good day.
You too.
Well,
Goodbye, Your Honor.